Hi, my name is Jakub. I'm a video game lawyer. Today I'm going to be talking about the legal implications of AI use in the game dev industry. Now, there will be a lot of abbreviations. Us intellectual property lawyers adore our abbreviations. You may have heard of DSM, meaning the Directive on Copyright on the Digital Single Market, DCD, the Digital Content Directive, as important or even potentially game-changing recent laws in the EU video games law. Today, however, I'm going to be focusing on other abbreviations, mainly databases, DB, AI, artificial intelligence, ML, machine learning. I'll try to ease you into the nooks and crannies of the topic. Now, a small disclaimer, this will obviously be legal education, so if you would need legal advice, if you or your company needs legal advice, please let me know. My contact details are in the end of the presentation. So, video game development is very often a strenuous, labor-intensive process. This is especially true with the ever-popular open-world AAA games. These amount to being a huge gamble on part of the developer who invests vast amounts of resources and talent into the development of these games and for extensive periods of time. So with these daunting tasks at hand before developers, artificial intelligence and machine learning algorithms provide vital breathing space, if you will, from quality assurance, QA, especially in open world games. You wouldn't want to have a vast amount of QA testers. You can just put a couple of algorithms going around the world and looking through any bugs and glitches. Anti-cheat. There is currently an sort of an arms race going on between cheat software developers and anti-cheat software developers. Open world generation, animation, difficulty throttling, chat moderation, or even match curation. Ad favorites like ad audience targeting, price modeling, and gamers' favorite, deep learning, super sampling. So will these algorithms be the soulless automatons foreshadowing a Butlerian jihad like in Frank Herbert's novel of Dune? Or perhaps it will be a friend indeed, helping out developers and publishers in a time of need. Whatever your stance on the subject, a few legal implications of the implementation of algorithms will need to be explored. So considering the basics, there is a need to identify, first and foremost, what can be owned and licensed to an algorithm implementation scenario. So for the sake of clarity, I will not be talking about video game AI as a gameplay mechanic, which deserves totally its own separate treatment. First, we will look into the core of rights to data and databases. We'll delve into how various IP is used in ML AI algorithms. We'll discuss the status of IP development with use of ML AI algorithms, and we'll look into the future regulatory landscape of ML AI use. So first things first, raw data is a must. This data should be protected usually, and it is protected as an important trade secret of a video game developer or publisher. And obviously this requires robust non-disclosure provisions in agreements. It is generally justified from a perspective of an entrepreneur to keep all data confidential. The law generally grants protection to such confidential data as trade secrets, i.e. such protection is granted if the entrepreneur has taken with due diligence actions to keep them confidential, which means that the entrepreneur has the will that the given information remains a secret, and that will has to be recognizable. So this in particular means providing access to information to individual entities, limited access to rooms, to disks, folders, access monitoring, password protection, other technical security measures, and naturally non-disclosure agreements. Oftentimes there is an initial and subsequent audits of whatever IT environment of a trade secret or confidential information beneficiary, of whoever generally gets the information, so that the risk of a leak is minimalized. I will be speaking in depth about database rights in just a moment, but for now it's important to stress that these rights are separate and totally different from copyrights. Copyrights, for instance, to any computer program servicing the database or extracting data thereof, and other IP rights. So data structured as databases may be protected as database producers' rights, database makers' rights, which is also sometimes called sui generis database rights. As well as these databases can be protected by copyrights as well to the database itself. And again, this is different from whatever software underlines or is underlying the servicing of such database. So this would mean, at least theoretically, a database which is somewhat creative. And such a database would be possible to be considered as copyrightable material. So this set of IP rights is the basis of the first key step in the development of any machine learning algorithm. So although trade secret protection of any asset is paramount in the video game industry, I'd like to focus your attention on the often neglected intellectual property right, meaning database rights. Regardless, these rights are often prove to be crucial to many industries. These rights also include a right to extract or download data from a database. So you see how this might be a basic right in any industry heavily relying on data. Now I will focus mainly on a EU law perspective, although also most notably the United Kingdom and Russia have introduced similar laws protecting databases. As far as I know, the US does not have a sui generis database right protection right enacted, but feel free to correct me if I'm wrong in the comments section below. So database in general means a collection of independent works, which are works or data or other materials basically, which are arranged in a systematic or methodical way, and these are individually accessible by electronic or other means, and there must be an element of a substantial investment as well on part in terms of quality or quantity in either obtaining, verifying, or presenting the contents of that database. So generally, to give you an important notion of what is actually crucial, the crucial item is structure, being a collection of data arranged in a systematic or methodical way. So database rights are of a two-pronged nature. Basically, there are two types of things that you can do with a database that would be subject to databases producers' rights. Basically, first of all, to extract data. However, one important caveat over here, this does not include merely accessing a single data point, but rather extracting a substantial part of the database. For example, establishing a scraping tool and scraping all the data or a substantial part of the data from a database, which that would definitely encroach on these exclusive database rights and would require a license if we would want to be compliant. And reutilizing would be closer or much akin to what is known to copyright lawyers as dissemination or of a substantial part of a database. So a database is an exclusive right granted, limited in time, granted for 15 years from the date of completion or making of the database. These database rights are conferred to makers or producers. And one important aspect, these may be both physical persons or companies. For these reasons, it is often recommended to, for the sake of avoiding any doubt at least, to have these rights attained from any cooperator or employee, just to make it all safe for the video game producer or developer. So what does that actually mean? What usually for lawyers, we seek answers to this question in jurisprudence and case law. So I'd like to present a couple of cases, the first of which, all of these would be based on the Court of Justice of the European Union. One of the first cases that came into existence on database rights was a case where the issue at hand was whether or not an objective which would underlie the extraction would have any relevance toward extracting taking place at all. So the concept of extraction is independent, what the CJEU said, of the objective pursued by the perpetrator or the user of the database, of any modification he may make to the contents of the materials thus transferred, and any differences. So where there is a body of material composed of separate modules, for example, the volume of these materials allegedly extracted or utilized must be compared with the total contents of the entire database. Especially if the latter, meaning that module, that specific part of the database which was extracted allegedly, constitutes a database in itself. So we have a clear tip, generally speaking, is if the amount of data downloaded or extracted may be considered a database by itself, this would be considered as an act of extraction and would be needing a license from a database maker. If a database is divided into separate modules, each of these would need to meet the criteria for a database. So in another interesting case, there was a matter of a collection of or an anthology of around 1,000 poems developed by a Mr. Knoop. As a precondition for that statistical analysis, the titles and opening lines of the poems were standardized, and the database maker, Mr. Knoop, developed a list of all verse titles which he compiled. As a result of this bibliographical research, both works in which the poems were published and their date of composition were identified. So there was a substantial amount of investment made on the part of the database producer. There was another party, Direct Media, which marketed a CD-ROM with 1,000 poems every person should have read, out of which 856 of these poems are also mentioned in the list developed by Mr. Knoop. So what Direct Media did is they selected these poems to be included on their CD-ROM. They used that list as a guide almost. It omitted certain poems which appeared on the list by Mr. Knoop, added some others, and generally critically examined the selection made by Mr. Knoop. And Direct Media took the actual text of each poem from its own digital resources and included them within their product. So what's important over here is that the Court of Justice mentioned that the transfer of material from a protected database to another database following an on-screen consultation of the first database and an individual assessment of the material contained in that first database is capable of constituting an extraction. So obviously it also depends, and primarily depends rather, on whether or not the operation amounts to a transfer of a substantial part of a database. So we have another clear tip. Extraction may be performed by any means or in any form. That indicates that the EU legislature generally mentions or seeks to give the concept of extraction a rather wide and broad definition. In another case, there was a Latvian company, or two Latvian companies rather, both developing a database for CVs, for resumes, to be accessed by employees and employers alike. So in that case, these companies were competitors, and basically one of those companies used a scraping tool in which basically there was an internet search engine specializing in searching the contents of another party's database, and the copies and indexes of that whole or substantial part of the databases were freely accessible on the internet, what is also important. That also allows users to extract or to search that database according to criteria relevant to its content. So basically speaking, use of a scraping tool to download or extract data and present that data as if it would be your own database, that would be not only extraction but also reutilizing that database, and would definitely encroach on database makers' rights. We would also like to stress the importance of future legislation in that context, in this specific context. In May 2021, the European Commission published an inception impact assessment on the forthcoming Data Act, the Data Act which would basically change or amend the current Database Producers Act regime. The Commission right now, as at time of recording this video, is still in the process of gathering views, gathering any opinions from stakeholders up until early September 2021. So once this video is up on public, that process will have already been finished. However, still, it's a matter of a couple of years where we'll be able to have a revision of the current regime towards database producers or makers' rights. So in that context, there were a couple of important questions posed by the Commission as regards to the introduction of the Database Rights Directive, with notably potential legal uncertainties as to the possible application of machine-generated data, whether or not machine-generated data by itself could be subject to the sui generis right to databases. A reviewed law within the Data Act, as the Commission states, needs to ensure in particular that the application of the directive does not pose an obstacle to access and use of machine-generated data and or data generated in the context of Internet of Things. There is also talk about a legal requirement at the EU level setting essential requirements for smart contracts. For example, by designating voluntary standards developed by the European standardization organizations or as harmonized standards, and thereby supporting interoperability of smart contracts across sectors and across borders, while also providing an important technical support for pooling and sharing of data within and between data spaces. The Commission also recognizes a need for preventing vendor lock-in and ensuring an open and competitive cloud market by allowing business users to easily switch their data and applications between different cloud computing services vendors, or porting their data back to on-premises IT systems without encountering contractual, technical, or economic barriers. There's also mention of a Data Governance Act, which the European Commission has drawn up a proposal on. This regulation will lay down basically the conditions for reuse of certain data held by public sector bodies, would also provide a supervisory framework for entities dealing with or providing data sharing services, and a framework for entities collecting and processing data made available for altruistic purposes. So Project Gutenberg, for example, comes in mind. So this is going to be interesting, how to reuse data for the good of humanity, generally speaking. So now that we have a general outlook, a groundwork, if you will, let's take a deep dive into machine learning. So first and foremost, I'm not speaking of the future, but rather the present. Agreements for implementing AI and ML technologies or algorithms already happen in, for example, very popular chatbots, or projects where certain amounts of data are being processed or analyzed by software as a service, where understood as having an algorithm basically spit out a report or a model. So these have applications in numerous industries: the pharmaceutical industry, energy, telecommunications, insurance, banking, finance, as well as obviously the previously mentioned the video game industry. Wherever there is a need to analyze and model large amounts of data. So these issues are relevant not only in specific implementations of AI or machine learning algorithms, but also can be relevant in situations where processing of data within a database is outsourced to a cloud computing service provider, or whatever data center which outsources its IT infrastructure for maintaining and accessing databases of its clients. So recently we have seen some disputes surrounding this topic, especially a contentious issue of who actually has the right to extract data from databases. So let's establish an understanding of the underlying concepts. First of all, of what an algorithm actually is. So algorithms are sequences of well-defined computer interpretable instructions, usually based on rules, functions. For example, if one types X, the screen displays X. Or if there is a specified content within an email, it will be marked as spam. In contrast, machine learning algorithms learn how to combine input data to make usable forecasts. Thus, the primary benefit of the machine learning algorithm over the standard algorithm, rule-based algorithm, is that there is no need to create or update these rules. An example of spam messages, and a machine learning algorithm has the ability to extract information about what messages users have marked as spam, and on that basis, and on the basis of that content, it may be able to extrapolate that to future messages. So ML systems, generally speaking, learn how to combine inputs to produce useful predictions. To make an advantage of a machine learning algorithm, one has to feed it vast amounts of data. That's where data comes really in. only then would deliver its full potential. The better and more structured the data, the better the predictions. So now these definitions are taken from one of the proposed regulations that we will be exploring further on. So an AI system, you already see where the understanding of what an AI system is from a legislature's perspective, where it generally will end up in. It's basically a system which displays behavior simulating intelligence by collecting and processing data and by taking action with some degree of autonomy to achieve specific goals. Now, the raw data, this is the key aspect of any AI or machine learning process. The raw data and databases are often put into training datasets or databases. And these are used to classify input by means of labeling. For example, if a message is tagged as spam or not. These training datasets are then processed by training models or programs, and this in turn would allow a training model or a training program, or a trained program rather, to infer a prediction to an unlabeled input, thus generating a model. So it's important to consider that the interim process of training an algorithm may produce valuable, although transitional items, such as training programs, training datasets, and other deliverables. These can be really complicated. These may also include deep neural nets, or can be configured as deep neural nets, often used actually to analyze images, videos, or other such audiovisual data. These nets can contain vast and complex configurations of training data sets and algorithms, all of which, it has to be stressed, can be protected by various IP rights, copyrights, database rights, know-how, patents, etc. This should result in a discussion between the parties on who owns what intellectual property and which intellectual property is licensed to the other party. So another level of complexity would also apply if the data sets themselves would be provided by the AI system developer. So that would make the IP or the AI contractor a database maker. So that would also mean that the video game company would need to acquire a license to either extract or also to reutilize data from these datasets. So the same rules would generally apply to use of training or trained algorithms. These may be executed or operated in different models, both on an on-premise model or software as a service model. Regardless, use of such applications or algorithms may require at least a limited license, just like any other software. So we now have a general understanding of what IP rights there may be in the development process, or the back end, if you will, of operating an AI or a machine learning algorithm. However, what of any items that are produced or generated or developed in the process, or as a result of the algorithm working? So as a rule, only human beings can be creators or inventors. Some jurisdictions have specific rules on generation of work by a computer, for example, in the UK. However, still, this only provides a rule to seek out a human creator or a human right holder. So a general rule of thumb is that solely persons or physical or legal persons, legal entities, can be holders of rights. This outlook is generally shared by the European Patent Office, which recently rejected 2 patent applications naming artificial intelligence as an inventor in the now notorious Dabis machine cases. However, recently, what's interestingly enough, in Australia, an Australian court has ruled that artificial intelligence can be named as an inventor of a patent. So in this respect, it must be stressed that although an algorithm as such may not necessarily be patentable, it would generally be admissible that inventions on methods of use of, for example, neural networks together with algorithms are patentable. As in these 2 examples, there are patent applications covering inventions using AI elements. The 2 presented examples are part of patent claims, and in one of these we have a description of a method of training a neural network by providing face identification or face detection functionalities. So in the first step, there would be a training of a neural network with a training set, which would contain faces generally. The second stage would comprise of basically comparing the first stage, the first training data set, with a second data set which comprises of non-facial images. And training generally would result in the neural network comparing the 2. Obviously, these neural networks can be vastly more complex and have numerous steps in the process. The more pressing matter, however, right now is rather who can be a right holder. The producer of an AI system, ML algorithm, or perhaps the algorithm operator, the person who would provide valuable input to the training data sets, or perhaps another intermediary. The Commission points out, following the study, that although inventions and works created autonomously by AI technology are still mainly the domain of the future, it still is of the opinion that AI systems should not be treated as inventors or creators. The study also shows that the current EU intellectual property framework and European Patent Convention seems broadly suited to address the challenges of AI-based inventions and creativity in general. The authors of this study conclude that the current law is totally capable of handling changes caused by the increasing use of AI in innovative processes, and in generally to attribute or not intellectual property rights where it is possible or not. In patent cases, there is also a requirement of sufficiency of disclosure. So the study mentions a potential feasibility, or at least a need for a discussion of a feasibility of a deposit system or similar legal mechanisms to AI algorithms, and for training data and for models that require patent applicants in appropriate cases to provide information that is relevant to meet the legal requirement of disclosure, while including safeguards to other rights such as trade secrets. So what is noteworthy to any intellectual property lawyer are the European Union Intellectual Property Office's plans on establishing a blockchain IP register project, and what is also interesting, a trademark prognosis and dispute resolution mechanism based on AI. So we see that not only does the European Union try to regulate this market, but also the EU institutions see the intrinsic benefits of AI use. So now I would like to focus on the future regulatory landscape of AI. First and foremost, the near future may pose a problem where an unfair competitor may want to implement an AI instruction to create a game 70% similar to XYZ. AI is already capable of creating statistically accurate, at least, Beatles records. I've seen a couple of instances of very simple rudimentary AI generated video games. So it may be only a matter of time before video game development follows suit in a broader context. So this results in a need to attribute some sort of liability to a person, to a perpetrator of such unfair acts. This is dealt with in the proposal for regulation on liability for operation of artificial intelligence systems. The model in the proposed EU regulation applies to situations in which the physical or virtual operation of an AI system, the operation of a device using such a system, or a physical or virtual process based on such system either takes a life of a natural person, causes damages to their health or cripples them, causes property damage to natural or legal persons, or causes serious non-pecuniary damage resulting in a verifiable economic loss. So now the question is whether this concerns, for example, infringement of personal rights of a natural person, for example, by a press release written by or with the use of a machine learning algorithm, or perhaps any content moderation or anti-cheats functionalities, which may or may not encroach on certain fundamental rights. So all high-risk AI systems and relevant industries will be implemented or listed in an annex to the regulation. As with the cybersecurity NIS directive, if it's not listed, it's not a high-risk system. So the general rule of thumb is that use of high-risk AI systems would mean that the operator of such would bear strict liability for any occurrences, for any damages, for any death that operation would result. Additionally, there's another draft EU regulation on the ethical principles for development, implementation, and use of artificial intelligence, robotics, and related technologies. It includes a proposed approach to requirements for AI system manufacturers, such as transparency, cybersecurity, or easy explainability. So all types of AI systems are to be developed, implemented, and used with a minimum cybersecurity baseline proportionate to identified risk. And this also means that safeguards are to be included and a failback plan in case of a safety or security risk. These should be developed, used, and deployed in a manner that ensures accuracy. And if occasional inaccuracies cannot be avoided, the system shall indicate to the extent possible the likeness of errors and the inaccuracies of the system to both its users and deployers. These have to be developed, used, and deployed in an easily explainable manner so as to ensure that there can be a review of the process or the technical processes of the technologies leading to a specific decision on part of the AI system. These have to be developed, deployed, and used so that they can inform users that they are encountering, they are interacting with an artificial intelligence system. A complementary, and this is one of the third proposal for AI regulation in this context, a comprehensive regulatory approach has been laid down in April 2021 with the Artificial Intelligence Act proposal, which applies not only to providers of AI systems, but also where merely the output produced by the system is used in the European Union. So the regulation proposal uses a similar toolset to 2016's GDPR, the General Data Protection Regulation. It first of all primarily lists prohibited uses of artificial intelligence, which include affecting the subconscious, abusing any vulnerabilities such as regarding age or disabilities. Social scoring would be also prohibited. So such use by public administration bodies or entities, which would allow the assessment or classification of the trustworthiness of a natural person, something that some countries are already implementing. Real-time biometrics in public places to identify potential victims, criminals, except for a vast array of exceptions. For example, targeted search for specific potential victims of a crime, including missing children, preventing a specific substantial and imminent threat to life or physical safety of a natural person or of a terrorist attack, detecting, locating, identifying any or prosecuting the perpetrator of or suspect of committing crimes such as murder, kidnapping, sabotage, rape, arson, terrorism, so grave offenses. On takeaways, there is perhaps one crucial one. First of all, leaving out any considerations of IP, ownership and licensing may lead to rather unnecessary discussions and headaches for either party involved in the development or use of an AI system. On the other hand, putting these matters in the heart of the terms negotiated from the beginning would definitely help avoid these issues. This can be done obviously by answering some simple questions. Who owns what on the outset? Who will own what in the end after the AI system is developed? Will the other party need to use such element or AI system or data set or algorithm in the future? Once this is established, your lawyer of choice would be able to forge this into a binding contract. Moreover, in terms of the regulatory framework, which is becoming to come into focus, with items of liability, ethical and risk management, and conformity management requirements, these may come into relevance in the next few years. Although the rules on high-risk AI systems seem not to be applicable in the video game industry, I wouldn't be so sure as to the veracity of that statement, which I just said. It generally would remain to be seen whether content moderation or anti-cheat systems would fall in this category or not, as they potentially may affect fundamental rights. Thank you for this presentation. If you have any questions, please feel free to contact me directly, and I will be available to return any questions or to answer any questions right now. Thank you.